petitioner appears self-represented by Zoom. The respondent appears self-represented by Zoom. This is a Zoom hearing. I'm going to swear in the petitioner. Ms. Dean, if you'd raise your hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. You are the petitioner in this matter. You have to answer. Are you
Yes.
the petitioner? All right. And were you a bona fide resident of the state of Kansas 60 days prior to filing this petition?
Yes, ma'am.
All right. And is Justin Michael Dean your husband?
Yes.
And are you asking for a decree of divorce from him?
Yes.
Are you telling the court that you are incompatible with irreconcilable differences?
Yes.
All right. And you'd like the court to grant an absolute decree of divorce?
Yes, ma'am.
There are two minor children of this relationship, KMD 2022 and PCD 2023. Is that correct?
That is correct.
All right. Are you currently pregnant?
No, ma'am.
All right. Are either one of you on active duty with the military?
No, ma'am.
You're asking that your name be changed to Sharp, either a previous or former name. Is that correct?
That's my maiden name. Yes.
All right, Raquel Marie Sharp. I will approve that. So you two have already divided all of your personal property. You've been separated for almost, well, it'll be a year in August. Is that right?
That's correct.
All right. And so you don't have any claims that the other one has any property that you want?
Correct.
All right.
There's none.
All right. And according to this, you have real estate in Andover. Is that correct?
Yes, both of our names are on the house that he lives in.
Okay. 1431 North Astor, Andover, Prairie Creek Edition.
Yes.
All right. And you are agreeing to him being awarded the marital residence. Is that correct?
Yes.
All right. And you've already moved.
Yes.
And you believe that that residence is worth approximately 200 and some thousand, correct?
Correct. When I looked it up, when I entered the paperwork last September, that's what it was valued at.
Okay. Do you remember the exact amount? And
240 something. I can look it up.
I know you wrote it somewhere. I'm trying to find 278.2.
Okay.
Do you know how much is owed on the house?
I don't.
Mr. Dean, do you know how much is owed on the house?
Approximately 190,000.
Approximately what?
190,000.
Okay. So you have approximately potentially 88,000 in equity.
That sounds about right. Yes, ma'am.
Divided by 2 would be 44,000 apiece. Ma'am, are you asking for any of that equity?
I believe I wrote that I would file a quitclaims deed to remove my name from the home. And then upon, if he was ever to sell it, that I would receive 50% of that profit.
Okay, well, I don't see how that can be enforced.
Okay.
First of all, quitclaim deed, when you file that, basically you're saying, I want off the deed. I'm not going to declare any interest in this property.
Okay,
I cannot remove you from a mortgage because
Okay.
it's a pre-existing debt that you entered with him.
okay,
He can refinance, or if you can convince your mortgage company to take you off, then that's fine. But you're gonna have to figure out how to get off the mortgage, or him refinance the property, or figure out a way to pay you. Well, I mean, they won't even care whether he paid you a equity settlement in your divorce. You're gonna stay on the mortgage until they release you.
okay. The mortgage company themselves.
Right.
Okay,
And one of the ways that's done is for one party to refinance. Now,
okay,
you can show them the divorce decree that granted the property to him as long as he makes the mortgage payment. And they might agree to take you off, but
okay,
they don't have to. And then it's gonna end up, probably a forced sale of the property if he can't refinance and he owes you money. Now, you're saying, well, wait till someday down the road when he does sell, but the house might be worth 3 times as much in 20 years.
right,
You're only entitled to the equity from the time of marriage until current, especially if you're not
right.
the payments or keeping the house up or anything. And the other thing is I don't know how to, I mean, normally this all gets taken care of at the time of divorce because basically the court loses jurisdiction over property or ordering payments or doing anything other than child custody and child support. So, if he doesn't sell the house for 15 or 20 years, I don't know how you're going to come back and petition the court to make sure that you got whatever money that you felt that you were entitled to.
That's fair. Okay.
So it makes it all pretty difficult. So I don't know, I don't know what you want to do. And you're not going to be able to buy your own home probably until you get off this mortgage. Most places won't let
Yeah,
you, unless you make tons of money, have two
I do
homes.
not.
Yeah. Okay. So, I mean, I can award the property to him and I can order him to pay, but I can't change a pre-existing obligation. The only thing I can do is if he quits making payments on the mortgage or on the house, you can file a contempt, but you have to come in and prove that he has the ability to pay and he's not paying the mortgage and it's affecting your credit. And then my only options with a contempt is to, if I found him in contempt, fine him, jail him. I can order jail, give him the keys by catching up the payments. I mean, that's all I can do is enforce what I ordered that I have the authority to order in the divorce decree.
Okay.
Okay. So I don't know if you want to talk to attorneys or you want to come up with some alternative. Do you all not have any marital debt at all?
The house.
Okay. Who is the mortgage company?
Freedom Mortgage.
Do you know what your rate is?
3%.
Oh, you wouldn't want to refinance that. Have you tried to contact them to tell them that you're going through a divorce and you're getting the house and your spouse wants off of the mortgage and she's going to sign a quitclaim deed?
I figured she would be the one to do that.
Well, no, you're the one that wants the property, right? And you want it free and clear of any claim by her. Of course, if you do that, you're gonna wanna have a judgment, um, for the equity, if you want equity out of it, that, you can take a judgment that says it's owed when and if the property's sold, but I have to get make it an amount of money. And I don't know that they will want to. Any judgments are on property. Whether it's child support, arrearage, whatever the case may be, a divorce settlement. And so I don't think for the purposes of freedom mortgage, they want there to be any kind of judgment that attaches to the property. Now, it'd be a secondary lien. It wouldn't be a primary lien. The mortgage company is always the primary lien holder. But, what about, retirement? Do you have retirement?
Yes, ma'am.
This
Let's see. When did you get married?
September 16th of 2017.
So not quite 10 years. Generally speaking, you may have a claim to each other's retirement for that 9-year period.
I don't want any of her retirement, ma'am.
Okay,
Same for me. I don't need his.
okay. If you have similar, I can't give you legal advice, but I'm required to make a finding that everything's fair, just, and equitable.
I'll give her whatever, if I ever sell the house, she will get her half. I can promise you that. I just want this over with, honestly, ma'am. This has been over a year in the making, and I'm just kind of done with it all at this point, so.
Yeah, I understand. But I don't want you to have a house that you don't have clear title to. I don't want her to have a debt she can never get rid of. I don't want you making claims that one or the other owes you money from the house that you never got paid that can't be enforced. So, I mean, if you want to have in here that you will pay her a minimum of $44,000 if and when you ever sell the house,
I am fine with that.
then I will put that in as a condition to a judgment. I'm probably not gonna be here 10 years from now on the bench, so it'd be some other judge looking at it to see if it's enforceable, and I'm not gonna make you any promises, but I can put that in, but I am not going to advise you on whether or not you should sign anything as far as a deed. Quitclaim deeds have to be filed with the Register of Deeds. And
Okay.
I don't know why someone personally, I wouldn't give up rights to something unless I'm removed from the liability and obligation of it.
Okay.
And so you're gonna continue unless he can figure out how to get you off, then that's that's something you guys can work on, is see if you can go to the mortgage company and say, here, if I sign this deed and sign the property over, will you just keep him on the deed and take me off?
Okay. So the quick claims would do nothing.
Well, yeah, a quitclaim deed filed with the Register of Deeds says, I declare no interest in the property.
Okay.
I have no interest that I can claim to this property ever again. Okay,
Okay.
so yeah, it does something, but it doesn't relieve you of your liability.
Right. Okay.
So most people would not want to have lost an asset when they still have liability for it.
Makes sense.
So, but you guys are gonna have to figure it out. That's why attorneys come into play. If you don't own much of anything, or you don't have kids, or you don't have land, or you don't have a house, it's not that difficult just for me to grant a divorce. But when it comes to this other stuff, I have to make particular findings, and there are a lot of legal ramifications, and If you don't know your rights, then you don't know what you're entitled to or how to secure them, unfortunately. All right, I did notice too with your parenting, it sounds like you're working this out pretty well together. But again, usually a parenting plan is a little more specific than, here's our monthly calendar, here's how we worked out the month of April. I generally don't like to do an order that says as agreed to by the parties, because again, there's nothing to enforce. If he keeps the children and doesn't return them to you, and you go to the police, they'll say, I don't have a court order that says that this is your time to have them. So if you come back to the court, which you would have to get something set, the court would not have a plan in front of it to be able to figure out who's violating the parenting plan or the parenting time. So again, it makes enforcement when there is a problem very difficult. Same with no child support. If you're not going to do child support, then you have to just split all of the expenses, but you have to know what those expenses are. And then if one of you feels like you're paying more than your fair share, if you come back to court on this case and you ask for child support, it's not going to be retroactive because there was no order in the first place. So those are the dilemmas that you face with this, and I'm trying to help you get through this, but it very well could create a situation where when you don't agree on something, you're going to end up back in court.
In the proposed child support worksheet that was sent to me,
Yes.
it showed that it would be payable by him in the amount of $235. The last I had seen as far as school for our daughter, and they haven't sent me the link to enroll her yet. So I don't know if I would qualify for her to get discounted or free schooling for her preschool. I don't know that yet. If I didn't, it would be 400 something a semester. The last that I had looked, which was earlier this year. The 235 would help put her through school and help with daycare costs for our son while we're both working.
Okay, I see. I didn't have this in my file. There is a proposed child support worksheet that Josh filed. It shows you making 69,612, him making 47,472. That puts you at 59.5%, him at 40.5. With 2 children under 5, amount per child, 1,012, that's 2,024. It looks like you did the shared. I'm not sure who you've got listed as making the direct expenses. And then health care. Have you seen this worksheet?
Yes.
Okay. And then you've got the daycare there that's split proportionately. And that ended up with each parent, 596, 579. Credit for health. All right, so it looks like what he's proposed here for me to approve is person not paying direct expense. So you would be paying the direct expenses and he would pay you $235 a month for both kids, and that would include the childcare and whatever else you're doing. Do you believe that that is fair and in the children's best interest?
It would be very helpful to support them with their daycare costs and through school.
Okay. All right, so I will approve the child support worksheet as submitted today. I will approve the parenting plan referencing that says agreed to by the parties. And a sample of it is the April attachment, kind of a sample, but it's basically a shared. I don't know, have you added up the time to know what the distribution of time is?
It varies by month. It's roughly 50-50, but it changes every month.
Okay. Well, I'm just gonna call it shared then. And the court does award joint custody, that's preferred. That's a legal status. I guess your holiday schedule will be as agreed to.
Right. Because it'll change every year with my schedule.
Okay. You're not doing any. So all exchanges are gonna be at the children's school, child care provider, or at Andover Turnpike area.
Yes, that's where we've been
Okay,
exchanging.
okay. Parents shall communicate by text. Mr. Dean, do you believe that this parenting plan as proposed has been working?
It's working for now. If and when she doesn't work 24-hour shifts anymore, I believe it's going to be difficult at that point, and I'm kind of curious how that would work, honestly.
Okay. Well, you're gonna have to come back to court and modify it or come up with an agreement and see if whatever judge is on your case will approve it. Parenting plan as far as time is presumed to be in the children's best interest if it is agreed to by the parties, within reason. Because it's believed that you all know best as to what works best and how much time should be spent and when and how. So that under the law, that does create a presumption of best interest. And then I'll find that this worksheet is in the best interest. I will find that you're incompatible with irreconcilable differences and grant you a decree of divorce. I will find that there is no debt other than mortgage to Freedom Mortgage, and that's the responsibility of the respondent. I will award the marital property to respondent. So on respondent, I'm going to show that you are responsible for Freedom Mortgage. and $44,000 to petitioner upon sale of the home, whenever that might be. Okay,
Yes, ma'am.
what else? All right, so if it ends up that you go talk to somebody or decide you don't like this, then, you can file an appeal. You have 30 days to appeal, and that means that you do not have the capacity to marry anyone else for 30 days. How much did you, Freedom Mortgage, how much did you say that mortgage is? So I can write it down here.
The original mortgage or what's left owed?
What's left? 190?
Approximately 190.
Okay. I'm just gonna write that in because she wrote what the value of the house was, she thought. And in this decree. So I want to write what the debt is so that it makes sense where that 44,000 came from.
Okay.
All right. All right, well, hopefully this paperwork's good enough for you. I will see that it gets filed, give it a couple days, and then you should be able to get certified copies, especially like for any transactions with the property or anything that you need to do there. But also the order for name change, so that you can do your driver's license and your social security card, anything else you want.
Okay. Thank you.